State of Ohio versus Ryan Fitzgerald, case number 18CA0031M. Each party will have 15 minutes to present your arguments. The appellant may reserve up to 5 minutes for rebuttal. If you're going to reserve rebuttal, just let me know, and I'll keep you apprised of the time. You both are probably aware that we do record the arguments, and they're on the court's YouTube channel, so we ask that you speak up and stay at the podium. We've read the briefs. Is that read at the podium? Or are we on there? Okay, because usually I thought it was up a little bit farther. Okay, you got a good video of it. Okay, we've read the briefs and are ready to proceed if you are.
Thank you, Your Honor. Good morning. Blaze Catter on behalf of Appellant Ryan Fitzgerald. I would request 5 minutes for rebuttal.
5 minutes? Okay, very good. Thank you.
Thank you, Your Honor. When analyzing the facts of this case, the record shows that there simply was not the requisite factual signs of impairment in order to either detain or arrest Mr. Fitzgerald. The most notable quote is that Mr. Fitzgerald had 100% sober eyes. His movements, his conversation were normal, within the well-accepted range for sobriety. He had not committed a traffic violation that gave rise to any signs of impairment. As the trial court found, there was no erratic driving. It was a garden variety speeding violation. This garden variety speeding violation, however, converted itself into a full-blown investigation on very few facts whatsoever. I would especially encourage this court to look at the comparison between the passenger in this case and the driver. The officer mentioned how obviously stoned on marijuana this passenger was. The passenger had red, bloodshot, glassy eyes, was unable to converse, was unsteady on his feet. And as the trial court found, and the officer conceded, these factors simply were not present with Mr. Fitzgerald. The video which was entered into evidence at the suppression hearing, I believe, is very key evidence to show and actually demonstrate the factual sobriety of the issue. So, turning first to the reasonable suspicion argument, this was converted from a traffic stop into an OVI investigation. At that stage, the reasonable suspicion analysis has to come into play when the officer has to have reasonable, articulable suspicion to elongate and change the nature of the traffic stop from its garden variety speeding into the OVI investigation. At the time that decision was made to begin the OVI investigation, there was not that reasonable, articulable suspicion when considering the totality of the circumstances. The first phase of the NHTSA manual is completely devoted to driving behavior. In other words, 1/3 of the total indicators that the NHTSA and the government would look at in order to determine impairment are contained in this phase 1, vehicle in motion. It's undisputed on the record that there were no clues on the vehicle in motion. Speed is only an indicator of impairment when it's 10 miles or more under the speed limit. In this case, it was a low-level speeding violation of 20 miles an hour. We're going somewhat fast, 30 into 25, around that area. That is not evidence of impairment. There was no weaving. There was no erratic driving. There was nothing at the time of the traffic stop that gave the officer, as he conceded in the record, any indication of impairment. So then we turn to the phase 2, the personal contact phase, because in order to then therefore convert the traffic stop into the OVI, he would need to be seeing indicators of impairment from Mr. Fitzgerald. I believe this court, in many cases it's heard, would say that one of the most common indicators of impairment is the condition of the driver's eyes. Bloodshot, red, glassy, those sort of indicators pop up in police reports all the time. And they simply weren't here. In fact, the officer conceded that they were 100% sober. Then you look to speech patterns. Is he exhibiting confusion? Is he exhibiting any sort of issues with coherence? And once again, the officer conceded that there were no issues of that at the time, that he was acting in a normal manner. His speech patterns were normal. He was able to converse at some length about his Florida license plates, about the route that he was taking. While it certainly does seem from the record that he might not have been on the most direct route to the Steak and Shake that he said he was going to, that by itself does not indicate a level of impairment. It simply indicates somebody out of state who had only been living in Ohio for a certain period of time, not having perhaps a mastery of directions.
Counsel, I'm going to interrupt you if you don't care.
Oh, certainly.
Can you remind me the time of day or night it was?
This was during the day, I believe. It was 4:44 p.m.
Okay. And,
Go ahead.
no, if you don't care. And with the order of events, when he pulled him over for speeding, when exactly did it detect the odor of raw marijuana?
It seems that it was pretty soon into the traffic violation. That he said it was immediately apparent that it was the raw marijuana, as Your Honor noted, and that was something that I believe the officer said was pretty immediately apparent. He continued conversing while he waited for backup because, as I believe the officer said, for officer safety purposes, he doesn't like to inform them of that until he's ready to secure the scene. It's certainly undisputed, Your Honor, that that odor of raw marijuana does give rise to probable cause to search the vehicle.
That's what I was just going to say. So you're not contesting that they could have, that delay or, continuance of the investigation was not legal?
No, not at all. We would
Okay.
certainly concede that they had the ability to detain, to search the car for probable cause. However, where that reasonable suspicion analysis comes in is then converting that into detention for a OVI investigation. As I believe a lot of case law, even if you're looking at not just the length of time it takes to turn into the drug dog, in those sort of cases, for example, what you're looking at eventually is when that investigation changes its nature and becomes something else. It's that changing of the nature where the reasonable suspicion analysis comes in. So I believe that even though they had the ability to detain in order to search the car with probable cause, that does not therefore automatically give rise to reasonable suspicion to conduct an OVI investigation without the facts and circumstances at issue.
Counsel, let me ask you this. Would you agree that there are factors beyond the driver or indicia on the driver himself that can be taken into consideration? For instance, Judge Carr asked the time. Now, this was an afternoon, but if it was 2 a.m., would that be a factor that could be taken into consideration?
Yes, Your Honor. The totality of the circumstances, I do believe, make it clear that any relevant factor could take into play. So the time, the location, those certainly can be relevant factors.
Was there marijuana found on your client's person? I'm not talking about the raw smell, but was there some found on your client's person?
I do not believe so, Your Honor. My memory of the record shows that it was found in the car, but I do not believe that in his pockets or under his direct possession was there any marijuana found.
Okay, if this was an alcohol, OVI, and there was open container, unopened container, flask, anything found in the car, would that have been a factor that could be taken into consideration?
It certainly could be, Your Honor. To that point, I would say that the fact that the odor of marijuana was raw instead of burnt is indeed a very relevant factor, that the officer was clear that he could tell the difference between the two. And since the raw is by definition unconsumed, I think it would be more akin in the alcohol to some sealed containers being found rather than an open container, which would be much more analogous to the burnt marijuana. And I also think that analysis would be further complicated if Mr. Fitzgerald were the only one in the car. Since he had a passenger in the car, I believe that it's a little more diffuse. It's not as easily tiable to him himself when you consider that all they found were raw marijuana in the car, and the passenger had certainly, without a doubt, been consuming some himself, as he exhibited some pretty obvious signs of impairment.
Of course, here there was also an admission that he'd been smoking, correct?
Correct. Although the exact nature of the admission is somewhat muddled, the passenger had admitted much more recent use. Mr. Fitzgerald, while admitting some, had indicated it was a much more considerable time period between the admission of consuming marijuana and the act of driving. And once again, we would note that one of the common symptoms, as the state and as the NHTSA manual indicates, the ARIDE manual, that marijuana impacts your sense of time. So in terms of a credibility determination, I think when you're talking about what the passenger is recollecting is when the time of consumption was, and when Mr. Fitzgerald's recollection of the time of consumption, you have to take the passenger's intoxication by marijuana into account when considering that.
But when you're just looking at reasonable suspicion.
Certainly, and I think that's part of the weighing of those facts and the totality of the circumstances.
And my understanding is, before they searched the car, they obviously both had to be removed from the car.
Correct, Your
And
Honor.
the passenger then, they obviously were able to see that he was impaired, and he had mentioned that they had both smoked marijuana.
Yes, Your Honor, that's correct.
And so, even if the driver of the car was not showing necessarily, telltale signs of impairment that you would usually see, you're still arguing that isn't even reasonable suspicion to turn the investigation into or to do the field sobriety test?
Yes, Your Honor, because when you look at the totality of the circumstances, the broader circumstances, the indicia of impairment simply aren't there when you have a lack of any indicators of erratic or unsafe or impaired driving. You have no personal characteristics of the defendant, no eyes, no slurred speech, no inability to comprehend. I believe that if I could point the court to the...
You're at 4:30 right now, 4 minutes and 30 seconds.
Thank you, Your Honor. As I would point the court to the some of the probable or the reasonable suspicion cases in the brief, primarily State v. Dixon and State v. Hall, that just because there is marijuana found and maybe an admission of consumption at some point does not automatically override all the other countervailing options of the clearness of intellect, the behavior. And then I would also like to turn to, once that investigation began, the probable cause analysis is both a heightened, over reasonable suspicion is both a heightened analysis, and the officer actually had, in certain ways, less evidence of impairment after probable cause because the roadside tests that were specifically designed to be indicators of drug impairment, Mr. Fitzgerald passed both of those. As the officer put in the record, he was trained in this ARIDE program, which is the next step beyond the NHTSA roadside SFST. And in doing that training, what it's supposed to do is prepare officers to maybe become drug recognition evaluators. But the ARIDE test, or the class itself, gives the officer 2 new tests at his disposal: the modified Romberg test and the lack of convergence test. Those 2 tests, it is not before the court at issue today, the scientific accuracy, reliability of those tests, because he passed those 2 tests, unambiguously passed. The officer said that he did not see any lack of convergence, and the modified Romberg test, which is where you tilt your head back and estimate the passage of time, the range by the ARIDE manual says that plus or minus 5 seconds is the acceptable range, and Mr. Fitzgerald was squarely in that range. He
2 minutes, 35 seconds left for rebuttal.
For rebuttal. Oh,
Yes.
I misunderstood you, Your Honor. Well then, I will ask the court. I will reserve the remainder of my time for rebuttal.
Very good. You'll have 2 minutes and 35 seconds.
Okay, thank you, Judge.
Counsel, you'll have 15 minutes.
Thank you, Your Honor. My name is Tom Morris, and I represent the state of Ohio. Marijuana OVIs are not novel. They are rare compared to alcohol, but they're getting more common with the winds of political change, so they're important, and I assume we're both going to be seeing a lot more of these. Steps are the same, though. I don't think there's a different standard for dealing with an OVI that's alcohol-based as a marijuana-based, and so there's certainly a lot of case law. We're going to have a proper stop. It can be pretextual, that's state first reg, but then you have to extend the detention, that's reasonable suspicion, to get to the FSTs. Then are the field sobriety tests done in substantial compliance. Then we get to probable cause, and then we get to take the test. So that's same as an alcohol, same as we had in this case. And in this case, there were certainly more, I think the focus isn't on the stop itself. It was a speed offense. So I don't think it's on the field sobriety test, although you mentioned that at the end. If you note from the judge's record, There's 3 standardized field sobriety tests. There's a few other tests that are located in the manual, but there's 3 standardized field sobriety tests. The HGGN test, the horizontal gaze nystagmus test. You do not expect that in marijuana cases. It just that drug does not affect the eyes in that way. So you look at the 2 remaining ones. They are the walk and turn and the one-leg stand. The judge made a factual finding of those that he did terrible on.
Well, counsel, hang on.
Sure.
Doesn't NHTSA say that the scientific studies and the purpose of those tests is, and I'm certainly not saying this correct, but it's some evidence of whether the person performing the tests is a .08 or above
There
of
are
alcohol.
Right. There are studies which show that there is the correlation between taking 2 of the 8 tests ultimately and testing over a .08. When they're doing the studies back in California in 1979 or whatever they're talking about, they're doing scientific studies. The scientific studies need numbers. So that's how they did it, was based on the numbers. They are trained not only the drug recognition experts, which are dealing exclusively with drugs of abuse. They're not dealing with the per se levels in the most cases. These are the tests they're trained in to determine impairment, determine that A1 charge, not just the AC charge or whatever the per se numbers charge. So while it was based on the original studies having a number there, it certainly does not take away from this is the tool they use for determining impairment. Certainly in my court, we do not get into the 79% chance that you're going to test over a .08, whatever those numbers are. I don't even know. I'm not allowed to get into those. So it is a tool that they are trained in their expertise to look for impairment, and that's the tools they use. Those 3 are the standardized ones, though, that are done all over the country.
Counsel, what I was wondering is, you've jumped right into the field sobriety test.
Sure.
But they're alleging that there wasn't even a reasonable suspicion to conduct field sobriety tests.
Right, and that's what took me off, because I didn't know that there was going to be an argument on the field sobriety test part. I think the focus of this court, because I think this court can look at what the judge determined on those field sobriety tests and said he did poorly on those. That was enough to be probable cause. But the issue that this is going to be in front of this court, and I think is the issue that the most important issue for this purposes is what does it take to get the reasonable suspicion to get to that point? So let's slow down and talk about what the officers were dealing with. We had a sergeant who pulls somebody over and smells the raw marijuana. That's probable cause. He's not in OVI mode. He's in, now I got to search the vehicle mode, probable cause, because of the smell. Places the defendant in the back of the cruiser and then searches, finds the said marijuana in the center console. Both parties admit they were smoking. The passenger was...
But counsel, he didn't know that before, did he? Did the defendant admit that he was smoking before he started performing the field sobriety test?
Yes. Yes, he did. He admitted to that.
I knew
before
the
he-
passenger did, but I thought that was during the field sobriety test.
I don't believe so, if I
Okay.
remember correctly.
All right.
Certainly, they received notice from the passenger that they were both smoking together. And one interesting note, and we're looking at probable cause, certainly can use hearsay in that case. But one interesting note is they said, well, the passenger looked really stoned, and therefore the driver was not stoned or didn't look as stoned. I'm sure we've all seen cases where the passenger is drunk and totally drunk. That doesn't mean that the driver was not impaired. We're not a drunk standard. We're an impaired standard. They're different. So one can be at various levels and still be impaired. Was he impaired? Well, the field sobriety test certainly was. You can see that based on the walk and turn and the one-leg stand. He mentioned the eyes being 100% clear. I would note that the one part that the judge or the officers have to look at during the modified romper is when they have their head back, are the eyes tremor. In this case, someone who's under the influence of marijuana may have tremors in their eyes. And in this case, they did have tremors in the eyes, which would show that something is psychoactive in the body. Something's affecting his body in such a way that maybe marijuana is consistent with that.
Counsel, I'm still a little confused. I'm going to keep going back to the
No,
field
please.
sobriety test. I'm sorry. Because let's just say, because Judge Callahan raised some good points in equating it to ODI with alcohol. If you have somebody that you pull over for speeding and the passenger says they have been drinking, the driver admits he had drunk, previously. But there's absolutely no other factors before you start performing the field sobriety test. Are you allowed to say just because a passenger said he had a drink to perform field sobriety test when there's no indicia of any impaired driving other than just him admitting?
Absolutely not. You cannot do that because it's legal to drink. You're allowed to drink, you're allowed to drive, you're not allowed to drive intoxicated or
Well,
impaired.
and that's where I was going, and you make a very good point. But with marijuana, I understand that it's illegal to smoke marijuana, for the time being anyway, in Ohio. But you still have to have a certain concentrated amount, 10 nanograms, right?
Yes, there's nanograms per deciliter, blah, blah, blah. I'm
Right.
not sure the exact.
For the.
There is a per se level for marijuana.
I was just gonna say for the per se level. And the other is, just like with alcohol, whether you're impaired. So you have to have indicia of impairment to do the field sobriety test.
Well, yes, or you could have indicia that this person is going to test over the legal limit. That's also a crime. So if
But you still have to have some indicia of that.
Absolutely.
You can't just say, okay, I
Reasonable
think you're
suspicion.
going to test over the legal limit.
reasonable suspicion, I believe, is the standard. So they have to have some reasonable suspicion that this person is either impaired or going to test over the legal limit. If I see someone drinking shots and then I get it behind them and they don't violate anything, and I saw them drink 12 shots of alcohol, I got probable cause to believe that they, or reasonable suspicion that they're probably over the limit. So this one is different, right? It's not alcohol, so we've got to kind of change the way we kind of look at it, because marijuana affects the body differently, but still can impair your ability to drive. That's something that an officer's trained on. They go through an A-Right, then eventually there's a DRE, a drug recognition expert on this case. We didn't need to get that because it tested over the legal limit, so that wasn't necessary, and that's after probable cause. So that part's not. But I would caution the court, and we can go back to this obviously as much because I think it's important, but it is the fallacy of the inverse. And I deal with this a lot where they say, well, you didn't see this, therefore you must have been sober. The way I describe the fallacy of the inverse is a philosophical argument through analogy. Judges work Monday through Friday. If you're not a judge, therefore you don't work Monday through Friday. Logically, that doesn't make any sense. The defense counsels argue that all the time. If you take a first grader's test and you miss 3, then you probably failed the test if you're an adult. If you get them all right, that doesn't make you a genius. You're supposed to get them all right.
But the difference is, the state has the burden.
I accept the burden. Obviously, I have the burden to show that there was reasonable suspicion to continue the stop to get to the point of field sobriety test. Field sobriety test is terrible on. Judge said probable cause. So what do we have? We have a raw odor of marijuana. We've got admission to smoking marijuana. We've got confirmation from the neighbor. We've got him in the wrong place, despite living there at
I'm
fourth place.
sorry, I hate to stop you again.
Please.
But you correctly keep saying raw odor of marijuana, and that's what the facts are. And I have read the judge's opinion and factual findings several times, and it just seems, as I read it, as he equates one of his factual findings for probable cause, the odor of marijuana, the raw odor of marijuana, I think everyone concedes here, is probable cause for the search of the vehicle. Isn't there a difference between that being cause for the search and the indicia of the possibility of smoking? I mean, trained police officers know the difference in the smell, which is why this officer testified that it was raw.
If I remember
Did the
correctly,
trial court?
and if you're asking me for a point on the trial, I don't remember. I get a lot of these trials. I apologize, but I don't have this one.
And I
But
would not expect you to
I
have this
believe, if I
memorized.
remember the testimony, there was a raw, and then there was a smoked odor that was located, but the raw was overpowering, and then when they got him out, he smelled the burnt.
Certainly that from the passenger, right? Or
No,
either or
from both, if I
Okay.
remember correctly, but please don't hold me to that one.
No, and
That might be
obviously,
the-
we don't have the record in front of us.
Sure.
Okay, thank you.
And I don't believe that's in either brief, is it?
I believe I just quoted an odor of marijuana.
Thank you.
the problem, the clearness of mind, clearness of intellect is certainly an indication, and whether or not he was lost on the way to Steak and Shake when he lived there in the Wadsworth area, moved to Florida, and then came back for spring break. Clearness of intellect is a problem. Long pauses. This is something that is more pronounced for under the influence of marijuana than it would be for alcohol. He did that when he was counting backwards. There's
But
admission.
again, those are probable cause indicia, not the reasonable suspicion indicia before you get to the field sobriety test.
The way I've always dealt with these are everything prior to the big three, the field sobriety test, kind of gets you to that point. They're doing a minimum evasiveness, asking them a few questions. Typically they're in their car still. This person was not in their car, not because of an OVI detection, but rather because he had to be, because they're searching his vehicle for illegal substances.
I'm sorry, maybe I misunderstood you. I thought you said that the long pauses were during the counting part of the field sobriety test.
Not the counting part of the field sobriety test, the counting part of the, do the alphabet forward, do the count backwards. This is done.
Oh, you don't consider those field sobriety tests?
Not standardized. And I think the difference is the level of intrusion. This is me just asking questions, typically it's on the side of the road, versus being out and standing there, you can't leave, stand on one foot, walk on a straight line. I think those are the second or the third phase, at least it is in the NHTSA manual, third phase field sobriety test. And then it goes through those standardized ones. Second one's vehicle in motion, or first one's vehicle in motion, second one is the initial meeting. And that's where it is in the manual list. Based on these, the judge reviewed this, he saw the witnesses, he saw the officer, he made credibility judgments. I don't believe this would be appropriate for this court to overturn those credibility issues or factual determinations, but to make legal issues based on what those findings were. And in this case, there were sufficient findings, I believe, to get us to that field sobriety phase, and once the field sobriety phase pops up, then to suggest that he did well on those tests. The finding that they were done in substantial compliance shows that he was impaired, and then ultimately he did test over the legal one. No other questions?
Thank you. 2 minutes and 35 seconds.
Thank you, Your Honor. Briefly, I do believe the record only indicates that raw marijuana was asserted. I do not believe, based on my recollection or anything, that there was ever any indication of burnt marijuana. Judge Callahan, to your point, we absolutely fundamentally disagree, the state and I, as to whether or not these field sobriety tests have any evidence whatsoever as to impairment. I believe the NHTSA manual makes very clear that these tests are validated only to the point of predicting blood alcohol content. There is no, in fact, the manual expressly says these are not to be considered evidence of impairment. So I do not believe that you can draw evidence of impairment from the particular battery of these standardized field sobriety tests. These are not normal tests. You're standing with your feet on the line. They're divided attention tests. They are very specifically fine-tuned to predict BAC, and I do not believe that you can draw evidence of impairment from those.
Counsel, what about the case law that says, well, in terms of scientific tests, like the, HGN, that would be excluded, but any layperson would be able to testify that somebody couldn't walk a straight line?
True, and if these tests only did talk about walking a straight line, that would be different. But these clues, these things that they're talking about they're doing terrible on, are very specifically designed. It's not a person just walking a straight line. It's a person taking heel-to-toe steps on a very narrow line, counting, hands down. These additional factors go into play, and that's why they're so specifically validated for what they do. And I just ask that you take the NHTSA manual at its word that these do not evidence impairment. Finally, I would really encourage this court to look at the State v. Simmons case that was notice of supplemental authority was granted. It's a very recently decided case out of the 10th District, and it deals exclusively with these indications where the defendant is a marijuana OVI and passes the tests designed to elicit out indicators of drug impairment. In the Simmons case, he passed the counting backwards. He passed the alphabet test, just like in this case. He passed the modified Romberg test. He passed the lack of convergence test, just like in this case. Those issues, I believe, are core issues for this court to consider. And if there are no further questions, I presume I am close to out of time, Your Honor.
Right on time.
I do appreciate your consideration of this.
Thank you both for your arguments today. The court will take the matter under advisement and issue a decision. The clerk of courts will certainly mail you both a copy of the decision once it is rendered, and the opinions are also posted on the Supreme Court's website. Thank you again for your arguments.
Thank you, Your Honor.